Legal 5. Be ready. Start. It appears that on the basis of some complaint regarding various persons who have obtained the appointment claiming themselves to be dependent of the employees working in the department under the dying in harness rules, some investigation was made without any notice to the petitioner, and it was found as alleged by the respondent that in the certificate submitted by the petitioner of the high school, the date of birth of the petitioner is entered as 15/11/1965, though in the certificate which has been submitted by the petitioner, the date of birth is recorded as 15/11/1969. The contention of the petitioner to this effect is that in case on the basis of some complaint, if the respondent was of the opinion that on the basis of some inquiry made thereunder the certificate submitted by the petitioner was having some discrepancy or wrong date of birth according to respondent is entered, the petitioner was entitled to have a show cause notice and opportunity. The appointment of the petitioner cannot be cancelled without any notice and opportunity that too after completion of about 17 years of service in the police department. In case the petitioner would have been given a liberty, he would have submitted a certificate issued by the high school board, which was submitted at that time of entrance in service. Without any notice and opportunity to the petitioner, the order impute dated 22/2/2008 cannot be passed. The petitioner has placed reliance upon a judgment of Apex Court reported in 1991 1 SCC 330 Shravan Kumar Jha and others versus State of Bihar and others. On the strength of the aforesaid decision, learned counsel for the petitioner submits that in case on the basis of some inquiry it was found by the respondents that certificate submitted by the petitioner is not correct, or they have come to the conclusion that it is a forged certificate, the principle of natural justice has to be observed and no order can be passed without any opportunity to the petitioner. The division bench of this court has held that termination without any show cause notice or opportunity to defend has been held to be violative to the principle of natural justice and has quashed the order of termination. On the other hand, the respondent filed a counter affidavit stating therein that in a writ petition filed by one Avnish Kumar, this court has directed that the respondent may inquire into the matter regarding the employees who have obtained the appointment under the dying in harness rules on the ground that their father or mother were in service of the respondent and died in harness, and on that basis some inquiry was conducted and it was found that the birth certificate submitted by the petitioner appears to be forged. Further allegation has been made that after inquiry it was found that only to get an appointment in the police department, the forged certificate of birth has been submitted by the petitioner. Therefore, the appointment selection of the petitioner is hereby cancelled. I have considered the submission made on behalf of the parties and perused the record. From the averments made by the parties in the writ petition as well as in the counter affidavit, it does not transpire that petitioner was ever given a notice and opportunity before passing the order impugned. Admittedly, the petitioner's appointment was of 1989.